Namaskar. Viewers, I welcome you to this new podcast from guide2ibc.com. This podcast is after 31st May 2026, whereafter I had informed you that there will be no podcast during June since we'll be updating the website with various amendments which had come in pertaining to Insolvency Bankruptcy Code. Well, after incorporating I'm happy to inform that on 30th of June 2026, Guide to IBC was possibly the first website which was updated with all the amendments to IBC code as well as regulations, all incorporated. Well, thereafter, there was a flurry of judgments, and we have selected 10 judgments out of them, and we are presenting them before you in this podcast. So with this, I take you over to the analysis of 10 judgments.
We are on the screen of section 3, subsection 27. Our topic of interest is topic number 4, which says that leasehold and or development rights are assets of CD under section 327 of, and the possession of the corporate debtor of the property needs to be protected. The case we are dealing with is of Maharashtra Airport Development Company Limited versus Mr. Vinod Kumar Kothari and another company appeal so-and-so of 2023 and 2024. This is a very recent judgment. Now, the basic thing behind this project, if you come to the excerpts of the judgment, the government of Maharashtra wanted a special purpose vehicle was conceptualized by them, the government of Maharashtra, for planning and development of Mihan project. Now, with a view to have a dedicated power source in Mihan project, Maharashtra Airport Development Authority, that is the airport development company, they invited expression of interest to build a power plant, coal-based thermal power plant on 62.5 hectares of land located in Mihan SEZ area on BOT basis, build, operate and transfer basis. It appears that this basis Abhijit Infrastructure Limited was selected, and the successful bidder and Maharashtra Airport Development Company Limited, they promoted a joint venture company in which Abhijit Infrastructure Limited took 74% share and 26% share went to Maharashtra Airport Development Company. The joint venture that is Abhijit MEDC Nagpur Energy Private Limited or corporate debtor, incorporated between the appellant and Abhijit Infrastructure, or along with went into CIRP. And there the problem started, and company went into CIRP and ultimately liquidation. So the problem arose and liquidators sold the land also. So the problem arose whether liquidator had the power to sell the land or not. Now this is a huge case. I think it was about 57 or 70 odd page judgment. Excerpts are of course much shorter, but I would request you to go through it. Now, having said that, let me take you over to the slide which I prepared for you, and I hope you'll like it. Now, as I mentioned, the main topic is leasehold and development rights are assets of CD under section 327, 3 subsection 27 of Insolvency Bankruptcy Code, and the possession of the corporate debtor of the property needs to be protected. Now, here the Honorable NCLAT said that appellant is a special purpose vehicle conceptualized by Government of Maharashtra and was entrusted for planning and developing Mihan project. Abhijit MADC Nagpur Energy Private Limited or the corporator, a joint venture company, was to be incorporated between Mrs. Abhijit Infrastructure Limited and the appellant MADC. And the appellant was to acquire 26% equity share in the project company, which we have already discussed. Abhijit Power Limited held 74% equity in the newly formed SPV as against contribution made to them by cash. And the appellant held 26% equity in the same by contribution of leasehold land. The CD of the project company was admitted to CIR. Wide order dated 6/10/2017, passed by NCLT under Section 7 of the Code, and Respondent 1 was appointed as IRP of the company. Wide order dated 31/8/2018, passed by a learned adjudicating authority. The liquidation process was initiated against the CD. The undertaking of this project company was sold by way of slump sale by the liquidator via public auction dated 21/10/2020. The legal entity of CD was auctioned and sold by the liquidator, and in this regard, sale certificate dated 19/12/2020 and 21/12/2020 were executed, and sale agreement was also executed on 24/12/2020. That means the company was sold, the assets were sold as a slump sale, and the entity of the company was sold separately. Fine. The CD having right to operate the project on BOT basis, the lease of the two lands was also made by appellant in favor of it only for 33 years. Therefore, CD was obliged to return the land and the project to appellant after the stipulated period of 33 years. All these rights pertaining to leasehold land and project which were meant to be enjoyed by CD were assets of the CD and may legally be included in the liquidation estate of CD and could also be sold by auction. Obviously, though CD was not the owner of the land, but it was having leasehold rights and its leasehold rights in its favor, and this bundle of rights as contained in the agreements was assets of the CD. The consideration which was payable for lease premium was in the form of equity shares of CD, and the equity of the CD was given to appellant in discharge or towards payment of consideration payable as lease premium for granting lease of land. So liquidator exercises wide power under Section 35 of the Code in liquidation process regulations to sell assets of the CD in order to maximize value for the creditors. So you will find this also in Section 7 or 35 also, this judgment. And this is an excellent judgment because even if it was given in 2017, the entire thing took place in 2020, the liquidation. So 3 years out of 33 years were gone. So the auction purchaser had the right to enjoy the project, had the right to operate the project, and have the enjoy the leasehold rights for 30 more years. And that makes it more important. And Maharashtra Airport Development Company Limited, though it was a owner of land, but had no right to reclaim the land till expiry of 33 years. So with this, we move on to the next case. Yes, we are on the screen of Section 3, subsection 30, which deals with secured creditors. Now, what does the topic say? The Industrial Development Authority or Housing Development Authority leasing land if provided in the contract is to be treated as a secured creditor. This particular case which we are going to deal with also has a Section 30 angle because there was a resolution plan. And our topic will be topic 26, which says that Section 30, subsection 4 provides that the COC may approve a resolution plan by vote not less than 66% of vote share of the financial creditors after considering its feasibility and viability and the manner of distribution proposed. Now, let us see the case. You will see that there are quite a few cases in this. Let us go to topic number 3. Yeah. So our case is Asset Care Reconstruction Enterprises Limited versus Mr. Vishwananda Sharma, RP, company appeal so and so of 2023. But this is also a very recent judgment and a huge judgment at that. Now, the crux of the case is that there are quite a few appeals in this, that there was Noida had leased a plot of land to the CD, which went into liquidation, which went into CIRP. Now, in the CIRP, the claim of Noida was not considered, initially was considered as an operational creditor. And Noida claimed that they should have been treated as secured creditors. There is also another angle, that is Asset Care Reconstruction Limited had taken over the loan part, the financial credit, from PNB Housing Finance Limited. And they claimed that they had the security interest included the flats. There were altogether 1,080 flats being constructed. So they wanted the security interest covered in all of that. And also they claimed that they have security interest over receivables. And they were not happy with they were not pleased. They dissented the distribution pattern in which the resolution plan, resolution amount was distributed. So with the conflict, the case went to NCLT and thereafter it went to NCLAT. So this is a long judgment. If I'm not wrong, it spread about 91 odd pages, something like that. So in order to make things precise and understandable, let me take you over to the slide which I prepared for you. The Honorable Court said, Honorable Appellate Authority said, the corporate debtor required and continued to acquire the project land under the long virtue of registered sublease dated 19/10/2012. Therefore, the rights accrued by Noida are intrinsically connected with the long-term assets of the corporate debtor, derived in entitlement to occupy and develop the project land. The rights assured by Noida are imposed on title agreement and the reliance of the statutory charges under Section 13 and 13A of Uttar Pradesh Industrial Development Area Development Act 1976. The registered sublease indeed contained all the requirements as laid down under Section 331 and 333 of the Code. And accordingly, Noida should have been treated as secured creditor in the resolution plan. While commercial wisdom of Committee of Creditors deserves due deference, approval of the COC cannot dispense with the requirement of examining legal rights that arise to an independently contractual arrangements governing the project land. So adjudicating authority failed to adequately examine the distinctive position occupied by Noida as the owner of the project land and as a party to the said registered sublease dated 19/10/2012. Resolution plan incorrectly subordinated claim of Noida to be that of an operational creditor. So, NCLAT suggested that the resolution plan treatment was Noida was incorrect. And they suggested that an addendum could be made in which their claim should be considered and placed back to the adjudicating authority. Now, as I said, that Asset Care Reconstruction Enterprises Limited, which is in short mentioned as ACRE, derived its rights from PNB HFL and cannot claim right greater than what was available to the original lender. As per demand notice or dated 22/2/2022, issued by PNB HFL under Section 13(2) of SARFAESI Act, the security interest of PNB HFL was limited to 121 unsold units only and specifically excluded 909 sold units. Security interest in favor of PNB HFL was created on 23/2017. By the date, 806 flats measuring approximately 15,21,415 square feet had already been allotted to home buyers. So once home buyers bought the flat, they owned the flats. So no security interest could have been created on them. Under Section 11, subsection 4, subsection B of RERA, creation of mortgage or charge over units already allotted to home buyers, or even in such charges created, it shall have no effect on the right of interest of the allotee. Hence, any change or any charge created by virtue of promoter over the unit sold prior to 27/3/2017, that is the date of mortgaging to PNB HFL, would be void and accurate charges would be limited to unsold inventory only. The resolution professional applied the proportion of unsold inventory, namely 25.64%, to the overall liquidation value of 151 crores, and on the basis the value for the appellate security interest came to 38 crores 71 lakhs 74,598. An amount of rupees 0% has also been provided to ACRE in the resolution plan, which is much more. It is about 70 lakhs, I suppose. There is a printing mistake. Though appellant claims that it had charge over receivables at the time of creation of CIRP, the property was only 30% complete. So liquidation value is determined on the assumption that corporate debtor stands liquidated on the insolvency commencement date, and home buyers cannot be expected to continue making payments towards incomplete project that has gone into liquidation. So their right on unsold inventory is based on what? We know that there is a change in the concept of valuation. The valuation is what you get immediately at arm's length. So if a company, it is liquidation value means what? On the date of commencement of insolvency, CIRP, it is considered the company has gone into liquidation. So the building was completed 30%. How do we assume that home buyers would continue to pay? So the value of their security interest on receivables is limited to not receiving money from home buyers. Therefore, future receivables cannot be treated independently realizable assets while determining liquidation entitlement. Merely because a dissenting financial creditor disagrees with the findings recorded by the adjudicating authority, the approval of resolution plan must not be interfered with. The approved plan was outcome of competitive process involving various bidders and extensive consideration by the COC. The allocation of Kalam's basis and assumptions was also unsupported by cogent evidence. There was no violation of mandatory provision of the code and material illegality in the approved plan. So there was nothing wrong with the plan. So from ACRE's point of view, objections raised by ACRE was inconsequential, so that were dispensed with. But the objection raised by Noida were relevant because they were to be treated as secured creditors. So with this idea, the plan was sent back to NCLT. So this is a complicated case and involves a good legal angle, and I would strongly recommend my viewers to go through the judgment. With this, we move on to the next case. This case which we are coming to is a very interesting case. You will find this case in section 5, subsection 17. You will find this case in section 36, as well as in section 53 of Insolvency Bankruptcy Code. Now, 517 deals with what? Liquidation commencement date. The topic says that the exclusion of time, which was lost in litigation, is an accepted proposition. NCLT, NCLAT, and the Honorable Supreme Court in several cases has directed for exclusion of time. Understood? Now let us see, go to 36, because in 36 and 53, it is the same. So 36 is the same, topic is same. The expression used in section 36(4)(a)(2) that all sums due to any workman or employee from Provident Fund, Gratuity Fund, and Pension Fund are due-centric and not asset-centric. The case is of State Bank of India versus Mr. Manoj Kumar Das and Company and others, Company Appeals so of 2026. The basic fact is there was a question as to whether PF and gratuity was payable. The company had gone into liquidation. It had the total time taken in the CIRP process and liquidation process taken together was about 1,950 odd days. Now, and there was no specific fund, the Provident Fund and Gratuity Fund. So the question arose, State Bank said that since there is no gratuity fund created in the balance sheet of the company, then how come money is payable to them? And secondly, if you look at 553(1)(b), it says that workers are entitled to 24 months pay, 24 months pay prior to liquidation commencement date. Now, liquidation took 1950 days. So from there, you calculate 24 days, 24 months. So in such case, nothing was payable to workmen. So, different question. And nobody could challenge the liquidation commencement date, which was... so, this is a very, very important case. An excellent judgment, spanning over 72 pages, if I'm not wrong. And I'll strongly recommend my viewers to please go through this. At least go through the excerpts of the judgment as featuring on my Guide to IBC website. Or if you can have a look at the judgment itself, it's an excellent judgment. But to make things presentable in this podcast, let me take you over to the slide which I prepared for you. Now, the Honorable Court said that there is clear exclusion of all sums due to any workman and employee from the Provident Fund and Pension Fund and Gratuity Fund, which was earlier part of the common pool of workmen dues as defined in Companies Act 1956 and Companies Act 2013. Payment of gratuity is not a charity, but a statutory right provided in favor of an employee. An employee earns this benefit by dint of his long, continuous, faithful, and unblemished services. I think we have covered this particular point in earlier one podcast. It's a Supreme Court judgment which said that the corporate debtors' financial statements were duly reflecting liabilities towards gratuity, provident fund, and other employee benefits. The expression used in 36483 that all sums due to any workman or employee from provident fund, gratuity fund, and pension fund are due-centric. They are all due-centric and not asset-centric. Even if no separate fund is available for provident fund, gratuity fund, and pension fund, they have to be paid out of existing funds of the corporate debtor. This is very important. Whatever is due on account of provident fund, gratuity fund, and pension fund, whether a separate fund is created or not, they have to be paid from the existing funds of the corporate debtor. Whether other people get money or not, that's irrelevant. The dues of provident fund, pension fund, gratuity fund of workmen and employees are not required to be distributed as per waterfall mechanism under 53(1)(b) of IBC. Now, we'll come to the exclusion part. The exclusion was sought since due to various litigations, including filing of different applications before adjudicating authority and filing of appeal in this tribunal. The appeal in the Honorable Supreme Court, CIRP prolonged by 1976 days. The workman cannot be made to suffer by various liquidations, on account of various liquidations in the CIP process, so as to make their entitlement of dues of 24 months prior to commencement of liquidation commencement date as liberty or nil. The object of IBC was to protect the dues of workmen for 24 months prior to liquidation commencement date and to give it priority ranking equally with secured creditors' debt. The claim is that for completing 24 months period dues for workmen, the period which was consumed in various litigations in CIRP period needs to be excluded. Now, when we compute 24 months period prior to liquidation commencement date without considering the exclusion as paid for workmen dues, which are contemplated in section 53(1)(b), have to be treated as zero. Liquidation commencement date, which is 26/11/2024, is statutorily fixed and cannot be changed. NCLAT directed that exclusion of 1656 days from CIRP period and 24 months before liquidation commencement date need to be computed accordingly. So deduct 1656 days. Liquidation commencement date you cannot change, but from CIRP period, you deduct 1656 days and calculate the entitlement. 24 months dues will automatically come. So this is absolutely in a nutshell. But this is a radical judgment, and in my opinion, it's a must read for all. So with this, we move on to the next case. We are on the screen of section 31 of Insolvency Bankruptcy Code on Guide to IBC website. Our topic of interest is topic number 10, which says that the resolution plan, once approved, reached finality. All dues stand cleared in terms of the plan, and hereafter no issue can be raised before any court of law or tribunal. The cases of Tata Steel Limited versus Varsha and another civil appeal number to Supreme Court. We have selected this case. We have multiple cases on this particular topic. But we have, since this is a Supreme Court judgment, and the Honorable Supreme Court has dealt with topics which gives a new dimension to the subject. That is why this case is selected. This is an unusual case in which we know that Bhushan Steel was taken over by Tata Steel, and the resolution plan was approved. Consequently, after approval of the plan, two operational creditors challenged the plan because they were of the view that their dues were not properly adjudged. So Honorable Supreme Court has done this judgment, has segregated it in various segments like operational creditors list, in approved plan, resolution plan not vitiated by manipulation or fraud, value of rupee 1 was not assigned to keep the claims alive, rupees 200 crore was available for quantified claims. I mean, there are multiple ones, and that is why this case should be a must bring for all. Now, without going into details, let me take you over to the slide which I prepared for you. Supreme Court asserted that all claims must be submitted and decided by resolution professional so that the prospective resolution applicant knows exactly what has to be paid in order that it may take over and run the business of corporate debtor. Once a resolution plan is approved under Section 31(1), all claims stand frozen and are binding on all stakeholders, including corporate debtors, its creditors, government authorities, local authorities, employees, and other stakeholders. Claims not incorporated in the resolution plan stands extinguished, withdrawn, or abated, consistent with the legislative intent of enabling the resolution applicant to commence on a clean slate, free from unforeseen liabilities. This we know from Ghanshyam Mishra judgment. All what I've read up till now. Now, the final list of operational creditors was prepared by resolution professional, was never challenged by respondent 1 Varsha. The intervener, Masrai Dasi Asin, the treatment challenged its treatment, but especially in the approved resolution plan, but its challenge was dismissed as withdrawn by NCLT on 25th October 2018. The order was never impugned and has attained finality. Consequently, the resolution plan in the present appeals is final and binding on all parties. The order has attained finality. The final list of stipulated claims which are subjected to dispute pending before various authorities have been verified with a notional amount of Indian rupee 1 only. Now, when a resolution professional faces the claims which are disputed before authorities, so obviously the claims have not materialized. So he cannot ascertain a value to that. So it is imperative, and it is usually done by all, that they are valued at 1 rupee only. No resolution plan can succeed if uncertain or unquantified claims are permitted to linger and resurface against successful resolution applicant years after approval. Such a situation would be akin to hydra-headed recurrence and is against the clean slate principle. The appellant SRA in its resolution plan expressly stated that since there was no surplus in liquidation value was nil, there was no legal obligation to pay any amount to operational creditors. Additionally, the resolution plan stipulated that all legal proceedings initiated by or on behalf of operational creditors shall immediately, irrevocably, and unconditionally stand withdrawn, abated, settled, or extinguished. This is what is most important. Additionally, resolution plan stipulate that all legal proceeding initiated by or on behalf of operational creditors shall immediately, irrevocably, and unconditionally stand withdrawn, abated, settled, or extinguished. Therefore, except to the extent of amount payable under the resolution plan, operational creditors shall have no right to or claim against the corporate debtor in respect of period before effective date. And what is the effective date? Effective date is the date of approval of the resolution plan. So this deals with the two important topics, that if a valuation done for disputed debts at rupee 1, that is acceptable. Even this SRA can mention that all proceedings, legal proceedings, initiated by operational credit. Why operational? Operational credit is financial, whosoever. will stand immediately withdrawn. And this is what makes this case exceptional. And I would recommend all to go through this particular judgment. With this, we move on to the next slide. We are on the screen of Section 33 of Insolvency Bankruptcy Code of Guide to IBC website. As you know, Section 33 deals with initiation of liquidation. We are on topic 46, which says that NCLT is not a forum for entertaining ex parte renegotiation or restructuring of payment mechanics under an approved resolution plan, particularly after the resolution applicant has defaulted on material milestones. This case is of Tagude Pte Limited versus State Bank of India and another company appeal so-and-so of 25. This is an interesting case because what happened is deals with in-cab industries, if I'm not wrong. Yeah. And the Utsavits, it deals with Ushdev International Private Limited, Ushdev International Limited. A resolution plan has been given by Tagude team. They had only paid 15 crores. And thereafter, for 2 long years, they kept on promising, but somehow the money did not come. The liquidation was ordered, and Tagude went to NCLT stating that liquidation should not be done because liquidation is the last resort, and instead they should be given an opportunity to implement the resolution plan. The matter went to NCLAT. So NCLAT made quite a few observations on the subject. And so this is an interesting read. This is an interesting read because herein what we are seeing is it's a different scenario. In the event that a resolution applicant has failed and resolution applicant is the appellant. So let me stop the screen share here and take you to the slide which I prepared for you. Tagude Pte Limited appellant was successful resolution applicant of the corporate debtor whose revised resolution plan was approved by learned NCLT on 3/2/2022. Mind you, and this judgment is of 2026, and that to 2026 June or July. The learned appellant repeatedly failed to perform its obligations under resolution plan, and despite lapse of more than 2 years from the plan approval order, failed to disclose the entire amount contemplated thereon. Pursuant to such non-implementation of resolution plan by appellant, the respondent 1 filed before the learned NCLT seeking initiation of liquidation proceedings against the corporate debtor, which was allowed by liquidation order. The appellant had proposed to make one-time payment of the entire amount contemplated under the resolution plan, which was rejected by Stakeholders Consultation Committee in its 6th and 7th meeting, SSC meeting. Despite approval of appellant SRA Tagude resolution plan on 3/2/2022, the same remained unimplemented over 3 years due to appellant SRA Tagude's failure to obtain necessary regulatory approvals for fund relocation from foreign investor. Appellant's core plea vis-a-vis implementation of resolution plan being delayed due to RBI approvals, readiness to park funds offshore, and grant further indulgence of implementation were squarely considered and rejected by NCLAT on 30/5/2025. So this had come to NCLAT and NCLAT had rejected it also. Appellant SRA Tagudes challenged the order of this appellate tribunal, which was met with dismissal by Honorable Supreme Court on 23/7/2025. So they had knocked the door of Supreme Court and it was denied. The issue raised by the appellant in the present appeal are substantially the same as those were squarely raised and decided against the appellant. Thus, the present appeal is barred by finality and principles of res judicata. The impugned order therefore rightly rejected such belated attempts and directed liquidation in consonance with the statutory scheme and settled jurisprudence. As per the section 31(4) of the Code, successful resolution applicants shall obtain all approvals required under applicable laws for implementation of the resolution plan within a period of 1 year from the date of approval of resolution plan. That's what 31(4) says. The appellant had committed nearly an amount of rupees 15 crore in the liquidation account of corporate debtor in January 2026 against the total planned value of 227 crores. NCLAT is not a forum for entertaining ex parte negotiation or restructuring of payment mechanism under an approved resolution plan, particularly after the resolution applicant has defaulted on material milestones. Unless indulgence defeats the guise of resolution, where implementation remains uncertain and reportedly deferred, this whole thing defeats the very purpose of the code. And that is why the liquidation was upheld. So this is a new thing, not a new thing as such, but definitely this type of cases don't come very often. So this is a good read, and I would suggest my viewers to please go through the case and the excerpts of it featuring in guide to IBC.com. With this, I take you over to the next slide.
Viewers, we are in the midway of our podcast. Some dynamic judgments you have already heard, and more are going to follow. Please like and share our video with others so that our site gains popularity.
We are now on the screen of Section 61 of Insolvency Bankruptcy Code on Guide to IBC website. Section 61, as we all know, deals with appeals and appellate authority. The topic of interest is our topic number 59, which says that an innocent party should not be suffering injustice merely because his chosen advocate defaulted. This case is of Hanu Steels Private Limited versus Rathi Power Tech Global Private Limited, Company Appeal so and so of 2026. In this case, what happens is the advocate, the party, had given this case to obviously everybody has to appoint an advocate. An advocate's clerk had not, they had initially corrected the defects, and then thereafter did not notice the defect. And so the application got rejected. And consequently, the appellant's entire thing was wasted. He went and informed that to IBC, to NCLT, but NCLT did not entertain. So this matter went to NCLAT. And NCLAT, so they dwelled on the subject and gave an opinion, which you will find interesting. And let me take you over to the slide, which will illustrate the matter better for you. What indicates that notice was accepted on behalf of appellant on 19/11/2025. 1 week's time was granted to file a reply. It is also not disputed that no reply came to be filed before the next date of hearing, that is on 8/12/2025. The adjudicating authority, finding that the reply had not been filed, despite opportunity, closed the right of the appellant to file reply. Insolvency proceedings under the code carry serious civil consequences upon admission of an application under Section 9. It is therefore imperative that a party is not denied effective opportunity to place its defense before such consequences ensue. Section 9, any insolvency is a very serious setup because what happens? The management of the corporate debtor gets suspended. So the entire business goes from the hand because then it will be very difficult for the promoters to run the business again, to get it back. And it is definitely not a desirable outcome. The courts are required to balance first the judicial proceeding to be conducted with diligence and discipline. And secondly, substantive justice should be defeated merely on account of procedural lapses. Meaning what? The court should be diligent and disciplined. But procedural minor procedural lapses should not defeat the legal substratum behind the matter. The court famously observed that judicial system should not permit party to suffer merely because of mistake of his counsel. The adjudication on merit should ordinarily prevail over technicalities and procedural defaults, unless malafide or deliberate negligence are established. Objective of the code is undoubtedly expeditious resolution. However, such expeditious resolution cannot be at the cost of fairness and natural justice. The order dated 8/2/2025, closing the right of appellant to file reply, cannot be sustained and deserves to be set aside. So here what they found is that the party, though it had failed, but there were valid reasons behind it. And they had genuinely tried to file a reply. So the court allowed, in the interest of justice, natural justice, the Section 9 petition to continue. So this is a beautiful judgment. And with this, I take you over to the next slide. We are still in the chapter of adjudicating authority, and we are in Section 62. Section 62 deals with appeal to Supreme Court. We are coming to a very recent topic from a Supreme Court judgment, which says that it is compelling and necessary to have absolute and total control over application and usage of AI. AI means artificial intelligence. Now, this is a very important matter because artificial intelligence has become a part of day-to-day activity. So this case is a Pooja Ramesh Singh versus Jammu Kashmir Bank Limited. Civil appeal so-and-so of 2025. This is a Supreme Court judgment pronounced very recently. It says that it is compelling and necessary to have absolute and total control over application of the usage of AI. In this particular case, what happened was, this was a case in which NCLT gave a judgment. And the matter went to NCLAT also. And NCLAT also looked at the judgment of NCLT and did not find any error there. Or NCLT in its judgment had quoted some judgments and which NCLAT did not, they rather believed on the judgments which were quoted by NCLT. The matter went to NCLAT, matter went to Supreme Court. In Supreme Court, counsel pointed out that certain judgments which were being mentioned are not found. So possibly they could have evolved out of use of AI. And Supreme Court detected those and came up with this order. So this is a scathing order, and I think this is of umpteen importance, especially for those who rely on AI to a great extent, which you should, but with a bit of caution. So let me stop the screen share here and take you to the slide which I prepared for you. Now, the Supreme Court said that artificial intelligence's extraordinary capability amid increased workloads of modern life is compelling is compelling professionals to adapt and employ AI for intelligent, efficient, and swift functioning, which is true. AI does work very efficiently, and you need it. I mean, more and more the society is advancing, the science is advancing. We are becoming more reliant on the technology, and AI is recent. The results can be gratifying, even inspiring. Yet, if left unregulated, artificial intelligence may infiltrate our intellectual work ethic and before long render us dependent on its vast capabilities. So, while the court recommends that we should use AI, but it is saying that we should not entirely depend on it because it will infiltrate our intellectual work ethic and before long render and make us dependent on its capabilities. It is therefore compelling and necessary to have absolute and total control over application and usage of AI. The necessity to clarify the position of law regarding a certain trait in AI responses, a tendency to generate non-existent, fake and hallucinated results when replying to a prompt. What happens in AI? You give a prompt and then it comes with the answer. It is serious lapse if a judge relies on such fake, hallucinated AI-generated material as precedents in support of determination. It is dangerous. PIUDCL had availed certain loan facilities from Jammu Kashmir Bank Limited. Respondent 1, which is Respondent 1, to secure these credit facilities, the corporate guarantee was executed by EIL. The National Company Law Tribunal examined the submissions and, upon finding the existence of debt and default, passed an order dated 28/8/2024 admitting Section 7 application. By impugned final judgment and order dated 11/9/2025, the NCLAT has dismissed the appeal, confirming the observations of NCLAT. Learned senior counsel appearing for the appellant pointed out that judgments relied by NCLT to arrive at the impugned findings, as referred by the NCLT in paragraph 12 of its opinion, are fake, non-existent, probably AI generated. That's exactly what I told. Even where case citations are accurate and accepted paragraphs from judgments are not traceable to those judgments in law reports. It is not in dispute that the judgment relied upon by NCLT are non-existent and some AI-generated paragraphs were wrongly attributed to genuine citations. So the case citations are wrong. Some paragraphs were generated in. So entire thing, the basis. The affidavit also indicates that so-called precedents relied by the adjudicating authority were obtained through its own research. That even makes it worse. It was not given by any lawyer. It was neither given by appellant or by the respondent. It was the judge who had done the research work and given this verdict when the case citations were called. Such decision is unsustainable and has to be set aside at the earliest. So this is a dangerous thing. And it is necessary for us. And this is what this makes this case exceptional. And it is a message to all of us that we should all use AI, but with a pinch of salt. We should not let our own intelligence interfere with it. Let AI interfere with our natural intelligence and wisdom. So with this, I take you over to the next slide. We are on section 94 of Insolvency Bankruptcy Code on Guide to IBC website. Section 94, as we all know, deals with application by debtor to initiate insolvency resolution process. The topic we are going to deal with is topic number 12, which says that the determination of locus standi at the threshold stage is therefore not only permissible, necessary for preserving the integrity of the insolvency framework. The determination of locus standi at the threshold stage is therefore not only permissible, but necessary for preserving the integrity of the insolvency framework. This case is of Mr. KCM Gowda versus Aditya Birla Capital Limited, writ petition number so and so. It's a decision of Karnataka High Court. And this what happened, Mr. KCM Gowda, he was a joint borrower, co-borrower. Now, Aditya Birla had moved a 13-2 petition in which he just impleaded. Now, based on that, he moved a Section 94 petition. As soon as Section 94 petition was moved, it went to, after it was moved, it went to NCLT. NCLT observed that he did not have any case as such, and so the case was dismissed. He did not appreciate the judgment, but instead of going to NCLAT, invoked Article 226 and went to High Court. High Court said that High Court warned him first that, look, you have an alternative mechanism where you can appeal. But why are you coming to High Court? And that, if High Court would adjudge on it, it might impose heavy cost. But the appellant was adamant and he went ahead. And High Court went into the case. This is a lovely case. In Section 94 has been analyzed in depth. And this is a lovely case. I would strongly recommend my viewers to go through this. While saying that, let me take you over to the slide which I prepared for you in order to make this understandable and brief, and so that understandable and brief. So what the Honorable High Court said is that the provision specifically enables a debtor who has committed a default to initiate insolvency resolution process by filing an application before adjudicating authority, which is right. The legislative scheme, therefore, does not contemplate automatic acceptance of every application filed under Section 94. The entitlement to invoke the provision is conditioned by statutory requirements which necessarily require examination by the adjudicating authority before the statutory process can be permitted to proceed further. That means the entitlement to invoke Section 94 requires prima facie examination as to whether there is a case to move on. It is not that just by putting in a 94 petition, in court is just not a stamping authority. Though it has been mentioned in Jwarika judgment that the judicial process commences after 99 RP's opinion, after under Section 99 is submitted. But even having said that, it does not mean that the threshold court will not see whether the case is at all maintainable or not. The jurisdiction cannot be conferred to be a mere assertion made in an application. The existence of jurisdictional fact must first be established before the authority proceeds to exercise powers under the statute. That's exactly what I say. Thus, when NCLT examines whether an application possesses the requisite locus standi to maintain an application under Section 94, it is not adjudicating the insolvency claim itself. It is not, insolvency claim is going to come after 99 order, 99 report. But the threshold has to be adjudged. And that does not mean that the insolvency claim is being adjudged. Such determination neither amounts to adjudication on merits nor constitutes an impermissible exercise of jurisdiction. The appointment of a resolution professional under Section 97 cannot be viewed in isolation. The statutory process presupposes that application has been validly instituted by a person entitled to invoke jurisdiction of adjudicating authority. The consequence flowing from an application under Section 94 are neither procedural nor insignificant, because the uh, in such case the moratorium would start. The legislature could not have intended such consequence should follow merely upon self-serving assertion made by an applicant without any scrutiny whatsoever by adjudicating authority. That's exactly what I said. That a legislature could not have contemplated a situation where a self-servicing uh, assertion would be accepted by court and without scrutiny, and they would let interim moratorium start. That is not possible. The determination of locus standi at the threshold stage is therefore not only permissible but necessary for preserving the integrity of insolvency framework. So this is a very important case. This possibly we are getting a case like this for the first time. That is why the topic has been created. I would strongly recommend my viewers to please go through the judgment because it's a wonderful read. I found it very interesting. So with this, let me take you over to the next slide. On the screen of dashboard of Section 95, topics of Section 95, which deals with application by creditor to initiate insolvency resolution process against a corporate guarantor. Our topic of interest is topic number 58, which says that a debenture trustee, on the instruction of the debenture holders, is empowered to exercise all rights and remedies to enforce and security interest, including exercise on the put option. This is of Gaurav Bhalla versus Beacon Trusteeship Limited, Company of Insolvency of 2026. It's a very recent judgment. In this case, what happened is a debenture trustee invoked Section 95. And the basic question was, can debenture trustee do this? Because debenture trustee, money is borrowed from debenture holders. So can debenture trustee proceed and section 95 be considered and section 100 order whether it can follow. The NCLT opined and the matter was challenged in NCLAT. NCLAT viewed on the thing and made a beautiful analysis. This is a long judgment. And while I strongly request my viewers to go through the excerpts of the judgment on Guide to IBC website, I would, in order to make things understandable for this podcast, let me take you over to the slide which I prepared for you. Now, Honorable Appellate Forum said that the wordings of Section 95 of IBC is unambiguously clear that it confers rights on the creditor singly or consortium of creditors to jointly file application and initiate PIRP of personal guarantors. The debenture trustee, on the instruction of debenture holders, was empowered to exercise all rights and remedies to enforce any security interest, including exercising put option. Put option is the legal option. This to So, debenture trustee. So that means what? The money is borrowed from debenture holders. Debenture holders don't work in isolation. They work through debenture trustee. And they can empower debenture trustee to invoke Section 95 or Section 7, whatever it may be, and to secure their security interest or exercise put option. Clause number 212 of DPG, that is debenture, that is deed of personal guarantee, clearly provides the obligations of guarantor was irrevocable while clause 14 clearly provided that the obligation of the guarantor was to be continuing nature until the final discharge date. So the guarantee was a continuous guarantee or continuing guarantee. When respondent one was specifically and categorically authorized to initiate Section 95 petition on behalf and for the benefit of the debenture holder, the debenture trustee stood fully empowered to do so. Section 95 of IBC not only provides right to the security trustee for holding security in favor of the financial creditor or consortium of creditors if the clauses of the personal guarantee so provides. The debt of principal borrower qua the respondent one was decided by adjudicating authority in its order dated 21/2026, which order was subsequently affirmed by this tribunal, that is NCLAT, on 25/2/2026, and later upheld by Honorable Supreme Court on 10/4/2026. So this matter went up to Supreme Court and the order was confirmed. In the absence of any evidence given by the personal guarantor regarding repayment of debt, the default of personal guarantor stood established. The appellant did not expressly deny the existence of DPG, that is, deed of personal guarantee, or its validity on its invocation, either in the reply of 15/4/2025 to the statutory demand notice or in the email addressed to them to the IRP on 11/9/2025. So it was never denied. The statutory demand notice of 10/4/2025 makes it unambiguously clear that respondent one had invoked the personal guarantee of the appellant in terms of the deed of personal guarantee and held applicant to be the personal guarantor. The contention that Section 95 application could not have been admitted by adjudicating authority on grounds of discrepancy in the date of default is frivolous and specious plea, and with which it is not impressive. So NCLAT upheld the judgment of NCLT and held that 95 petition was maintainable, and NCLT could issue an order under Section 100 also. So this is a common case, but this is a case where you're dealing with debenture trustee, and that's what makes it most important. Because in debenture agreement, whether a deed of personal guarantee is there or not is most important. A deed of personal guarantee, if it is there, what needs to be found is that whether it is continuing guarantee or not. And then if it is continuing guarantee, then Section 95 can always be revoked. So with this, we move on to the next slide. We are on the dashboard of topics of Section 100 of Insolvency Bankruptcy Code on Guide to IBC website. And as we all know, Section 100 deals with admission or rejection of application pertaining to insolvency of personal guarantors. Our topic of interest is topic number 13, which says that the invocation letter, recall notice, statutory demand notice, and the recovery proceedings before DRT should clearly demonstrate that financial creditor took consistent steps to enforce the guarantee. The case is of Vijay Pandey versus Small Industries Development Bank of India, Company of Insurance of 2025. If we go to the case, we will find that this was a case of NCLT Allahabad. And this comprises of two appeals, one by Vijay Pandey, another by Maya Pandey. They both challenged because they based their argument on invocation letter of 2021. Now, NCLT admitted the case and the matter went to NCLAT. NCLAT adjusts the matter. This is a beautiful judgment. And one should go through it because it essentially deals with how the banks normally go to go to RDPFI, and go to DRT. And then they come to NCLT. So the process is similar in all respects. But the implication of it has to be understood. So with this, that's why I say this is an interesting read. And I request everyone to go through the excerpts of the case featuring on the website. With this, let me take you over to the slide which I prepared for you. The Honorable Appellate Authority stated that prior to initiation of proceedings under Section 95 of the Code, an application under Section 19 of Recovery of Debts Due to Banks and Financial Institutions Act 1993, being OA number so-and-so, was filed before DRT, Lucknow on 5/3/2022. Above was against the corporate debtor as well as appellants in their capacity as personal guarantor for recovery of loan amount of 1,11,82,009, along with cost, interest, etc., from personal guarantors. Respondent 1 has been relying on the invocation letter dated 26/11/2021 in terms of guarantee agreement, well before initiation of proceedings under Section 95 before learned adjudicating authority. So the aim was to invoke limitation. This fact was also noted by learned DRT in its judgment dated 17/10/2023, where it issued recovery certificate for recovery of debts from corporate debtor as well as personal guarantors. So on 2023, 17/10/2023, a recovery certificate was issued. And as we know, recovery certificate gives a fresh lease of life to the debt. Corporate debtor and the personal guarantors who are appellant in the proceedings did not choose to appear before learned DRT, despite service of notice summons through all modes. Clause 23 of Deed of Guarantee provides that any demand or notice shall be deemed to be sufficiently served if it is sent to the last known address of the guarantor. So the recovery certificate and the summons were rightly served upon them. And they did on their own, they chose not to appear. The demand letter of 1/2/2022, which has been issued by Learned Counsel of R1 to CD and the appellants. It is seen from the records that proof of dispatch of the said letter by speed post has been placed on record. Thereafter, a statutory demand notice of 2012-2022 was issued, which specifically referred to the earlier invocation of guarantee. Statutory demand notice, the DRT proceedings, and the subsequent enforcement of all actions indicate that financial creditor had consistently asserted its right under the guarantee. The objection raised by appellant is therefore essentially technical in nature and does not dislodge the substantive fact that the guarantee had been enforced by the creditor. And there was a recovery certificate issued by DRT also. The adjudicating authority had the benefit of considering all relevant materials before arriving at its satisfaction under Section 100 of the Code. The invocation letter dated 26/11/2021, recall notice dated 4/2/2022, statutory demand notice dated 20/12/2022, and recovery proceedings before DRT clearly demonstrate that financial creditor took consistent steps to ensure the guarantee, enforce the guarantee. So this is the following of procedure is very important. Though it was not in NCLT, it was in DRT. But NCLT took note of it, that they have been constantly chasing, and you cannot dislodge it just by becoming hyper-technical and finding flaws in the case. And especially the recovery certificate was there. So with this, I think we come to the end of our presentation, but let us go to the concluding part.
We have come to the end of our presentation. I do hope you like the presentation, and I will be very happy if you will please like and subscribe to the channel and make your friends, colleagues know about our website. This is a lone venture. We do not do any marketing. So we believe in word of mouth spreading, and so that the website gains popularity. Secondly, we don't do a podcast based on compulsion. We do it based on judgments which are there. So though I'm hopeful of coming back to you after a fortnight, but it depends on how the judgments come in. And hopefully, if there'll be a good number of judgments and dynamic ones, I'll definitely return back to you towards the middle of next month. Bye for now.